Hello, everybody. My name is Juan Carlos Brandos. Thank you so much for having us today in this show with one of the attorneys in the law firm of Margaret W. Wong and Associates. And today we're going to be talking with one of the attorneys that are specialized in the immigration law, of course, but also the criminal law related to immigration. So he can talk from as low as a speeding ticket or a traffic violation to real crime related to your immigration case. So, how does affect criminal cases or criminal records to your immigration situation? Well, today is a good day to talk about that with the attorney Rutanio Rocker, who has been a judge, he has been a prosecutor, and now he's working for the last 2 years or 3 years with the attorney Margaret W. Wong in the law firm. So let's welcome the attorney Rutanio Rocker. Welcome and thank you so much for having me today. How are you doing?
I am well, thank you, and welcome to you. Thank you for having me today.
Thank you so much. And well, I would like to start with one of the questions that has been on top of the topics and the news. Is the situation with Venezuelan people in New York, the people that has entered into the United States with parole at the border. They have been paroled in, and they have a process against them, or they are going into removal proceedings. But meanwhile, they are staying in shelters. Some of them are shooting at people. Others are riding motorbikes in Manhattan, driving the people crazy around there. So, what is the situation, the legal situation with these people? If they commit crimes, are they going to be put in immigration hold, or this is something that is not very likely to happen?
Well, when you come to the United States, please understand the rules are much different for those coming from other countries and seeking asylum or some other type of relief in this country. For example, we all know that there are a lot of US citizens who sometimes have DUIs, and they have a number of DUIs, and those DUIs are not held against them as strongly as DUIs are held against those in the immigrant community. My point is, if you commit a crime and you are from the immigrant community, it could adversely affect your ability to adjust status in this particular country. And you don't want that because the rules are already against you. So what you want to do is stay as clean as possible from a criminal perspective and make sure that you do what it is you need to do and not get any crimes or charges against you. And if you do get a crime or a charge against you, then you need a good lawyer. And especially when I say a good lawyer, I mean one that not only does criminal law, but either knows the immigration law or knows how to contact Margaret W. Wong and Associates, because we have individuals here who understand how the criminal law would affect your immigration case.
So if, for example, there was a guy that I think he was in Columbus, Ohio, and he was inviting people to invade abandoned houses in that state. So apparently he did that. His videos on TikTok and other social media got to the White House, and that started some alarms in the government. So they found out that this guy had to report in front of ICE, and he did not do that. So after that, they went to the house that he was apparently staying, and they detained him, and he has been detained for a while. So the question would be, is this kind of people likely to be deported? Is this a priority? What kind of crimes are a priority for deportation?
Okay. With respect to this particular example, in Ohio, we have what's called misdemeanor trespass and then we also have felony trespass. And felony trespass, beginning with a felony of the third degree, if you tell somebody or you go into an abandoned house, that could be a felony of the third degree. And because the sentence is more than 1 year for a felony of the third degree, the bottom line is you could, in fact, be removed from this country because it would be considered an aggravated felony. And an aggravated felony is anything where the sentence is 1 year or greater. So crimes like murder, crimes like felonious assault, crimes, other felonies, sex crimes that carry more than 1 year, you could, in fact, be removed from this country. Now, the gentleman who put on his TikTok or social media platform and was encouraging people to go into abandoned homes, that's not a good look, because you are inciting people to commit a crime, a felony to be exact, because most prosecutors nowadays do not charge the misdemeanor 4 criminal trespass in Ohio. They charge the felony 3 trespass, which carries with it, again, at least a year or more in terms of a sentence. So the bottom line is that is not something you should do. And I would hope that people would not be listening to someone telling them. I don't know what his reasons were for asking people to do this or inciting people to do this, but it is a crime to occupy an abandoned building or an abandoned property.
Okay, thank you very much, attorney, for this answer. And yeah, this is a situation that people need to learn, that they are living in the United States of America. If you commit a crime, you are most likely to pay for it than you are in other countries. So this is a question. It's not related to criminal cases. Let's see if we have an answer for this. Hello, how do you get USCIS to apply for 245K to your AOS? Do you write a letter? Is there a form to complete to let USCIS know you are eligible for 245K?
To the best of my knowledge, USCIS has a website, and on its website, they have all of these forms that you will need. So if I were you, I would go to their website and I would check first to see if they have the 245K form. If they do not have a 245K form, you should call Margaret W. Wong and Associates, because we can help you with that.
Okay, thank you very much. And we have some other questions. This person says, hello there, I have a question, I think. I went on student visa in year 2007 and got deported in year 2012. I was deported as I stopped going to school and was out of status. My query is, my mother is a green card holder and I already have have a pending family petition, F2B, priority date June 2018. I-130 is already approved. My parents are back home and my mom has been going medical issue. Is it possible if I can get a visitor visa just to take my mother back to the U.S.? She is unable to travel by herself.
All right. That may be possible. It may not be possible. You would have to check with the embassy of your country first to see if they would be willing to give you that particular visa. But the problem is, if you were already subject to an order of removal, then even if you come through the airport, and an international airport, whether it be Houston or Dallas or any of the bigger international airports, or even if you attempt to cross the border, USCIS or ICE may in fact deny you admission into the United States, even with a valid visa. I have a case in which I had a client that had a valid visa and he was returning to the US to deal with some issues here. Unfortunately, he was detained at the airport, I believe it was in Houston, Texas, and he was denied entry. So the fact that your home country may grant you a visa to visit, does not necessarily mean that the United States will honor that visa.
Thank you very much, Attorney Ruitanio. And don't forget that the attorneys in the law firm of Margaret W. Wong and Associates are available to talk to you and to answer your questions every Thursday at 12:30, and in the Spanish channel Wednesdays at 9:30 a.m. But they are available to talk to you if you make a call to the phone number 216-279-3984. You make an appointment with them, and you can eventually get a consultation with the attorneys in the law firm of Margaret W. Wong. They have offices in 7 cities of the United States: Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one: 216-279-3984, 216-279-3984. Next question. Says, hi, my brother lived with some people that I really don't know very much. One night, the guy was drunk and he was beating up his wife. Someone called the police and they went to the apartment. Nobody wanted to open the door, so my brother did. The lady said to the police that everything was okay, and the police left. The guy who was beating up his wife took it on my brother, but my brother punched his face and broke the nose of the guy. They called the police, and my brother left the scene. He surrendered later on, but he has been detained for 3 months already. My question is if he can be released, or if he will be, or if he will end up being deported.
Okay, that's a very good question. When an individual is in ICE detention, unfortunately, the rules are a bit stricter. Your brother does not have to be convicted of a crime to be held by ICE. He can be detained by ICE simply based on the charge. For example, in this particular instance, it looks as though your brother may have been charged with some type of felonious assault because he broke the individual's nose. That being the case, that is an aggravated felony, which I'm certain carries with it more than 1 year. Now, in the immigration world, the only thing that we can do, or an attorney can do, is in whichever state that your brother might live in, is to try to get that reduced to something that is not an aggravated felony and that has less than 1 year. The problem is that while he is in ICE detention, generally those proceedings are sped up, meaning that they take it to the IH hearing rather quickly, and so that they can get to a decision. Sometimes they may release an individual on bond, but most times when it deals and comes to an aggravated felony, the immigration judges are reluctant to do that. So it is quite possible that given this scenario that you have posited here, that your brother could in fact be removed from this country.
Thank you very much, Attorney Ruitanio. And don't forget, if you want to talk to the attorneys in the law firm of Margaret W. Wong and Associates, you need to call the phone number 216-279-3984, 216-279-3984. I have a question that is related to those cases that some people don't realize, that driving under the influence here in the United States is so bad. So I've seen people from several countries, but I will mention some of those countries are Nigeria, other countries, Guatemala, also Venezuela, and I will just mention those that I know many cases. What would be your recommendation for these people that come and try to drive under the influence here?
I would strongly suggest that you not. It is not fair, but in an immigration setting, a DUI charge is viewed very seriously, and it only takes one DUI charge, and depending on the immigration judge that you get, that could have you removed from the country. It is basically looked upon as you are not an individual that can be viewed as how do I want to put this, that you are not safe for the country. I know of a number of defendants who have DUI convictions who are American citizens. In fact, in Ohio, we have what I call party plates. Individuals, they're yellow plates with red writing. And you know that those individuals have more than one, have several DUI convictions. But they are only allowed to drive under certain circumstances, and they get these plates from our driver's bureau here in Ohio. Bottom line is, I would not suggest driving, whether you are an American citizen or whether you are an immigrant seeking status or you're not seeking status. I would not advise that you drive under the influence. I have a case right now in which an individual, unfortunately, has 5 DUIs. I am anticipating that when we go before an immigration judge, that unfortunately, that is going to play very heavily against him. I do know that when you have these kinds of criminal charges, DHS, Department of Homeland Security, is not willing to grant you prosecutorial discretion to dismiss your case. In fact, they will tell you because of your criminal history, they will not do that. So it works against you on all levels, and I would advise just don't do it. As the commercials say, if you are too drunk to drive, get an Uber. If you don't have a designated driver, get an Uber or a taxi cab for those people who are my age. We remember when there used to be those kind of things. Now younger people take the Uber situation. Whatever it is, do not drive while you are under the influence, because the bottom line is it could lead to a whole lot of bad consequences for you.
Thank you very much, Attorney Retanio. And yeah, this is a good advice that people need to learn. And not only because you can get arrested, you can get in trouble, but you can also die in a car accident. There was an Argentinian soccer player that got into a bad wreck. I don't know if it was in Argentina, but you can see the car when he was driving running into a gas station, and he almost killed a person there. And it doesn't matter who you are. If you drink, please don't drive. Don't think about driving, especially in the United States, because here you're going to get arrested and you're going to get in bad trouble.
Yes.
Okay. I lost my green card, passport, and all of my documents while I was in Europe. How can I file for a new green card, and how long would it take? Thank you.
All right. I would strongly suggest that you call Margaret W. Wong and Associates at the number that is on the screen. We can help you do that. Right now, it's probably going to take a while. I hate to tell you that. They are a little backed up.
Yes, and we really don't know. It may take 6 months, 9 months. It can take a long time.
It can.
Yeah. Thank you very much. And next question is: I was caught in shoplifting 6 years ago in a Walmart. I was given a bond. I left the U.S. and didn't show up at the court. Came back through the border and now applied for TPS as I am from Venezuela. But now it popped up in the system. So how can I solve this situation? I'm not a bad person. I just made a mistake back then.
I got it. And probably when you left the country, it really didn't register to you that this could be a serious situation. I don't know how old you were at the time, but I am aware of a situation with a juvenile where they were caught for shoplifting. And when they reinvented themselves, they went to nursing school, became a nurse. And here in Ohio, we do background checks through the Bureau of Criminal Identification and Investigation. And unfortunately, when they did the background check, they found out that they had this shoplifting charge that they had been convicted of when they were juvenile, because they can see your juvenile record. Bottom line is, you should hire an attorney in the state in which you live, whichever state that is, to try to help you to get that resolved, meaning that hopefully they can, since it's been 6 years, maybe the prosecutor might be willing to dismiss the case, or seeing if they can get you something that doesn't have to be a crime involving moral turpitude, because shoplifting is theft, and theft is viewed as a crime involving moral turpitude. In addition to that, depending on your state and how it is defined in your state, it could also make it a crime involving moral turpitude, or it might not, but it would depend on the statute in your respective state. So my advice would be to get yourself an attorney in your state, whatever state that is, and have him or her try to get this resolved for you.
Okay, thank you very much, attorney. Well, interesting cases. Yeah, please give us a call. The phone number is 216-279-3984, 216-279-3984. Just a personal question. I know a person that was caught dealing with drugs back in the 90s. After that, I think he got arrested. He got married to an U.S. citizen, and he has been married to her for over 30 years now. The thing is that the lady is U.S. citizen, the children are U.S. citizen, they are already over 21. But the question is, because he tried to do something, but then the FBI showed up at his house. So they got scared. He didn't try nothing else. Is there a chance that he could vacate that case or clean that record after so many years and probably try to get an immigration status?
That is a very good question. If he was caught in the 90s, one, it would depend on what he was caught with. If he was caught with what I would call hard drugs that are under the federal statutes, it might be a little difficult. If he was caught with marijuana, it might be less difficult. But the bottom line is, in the 1990s, if my memory serves me correct, I was around at that time. I do not believe that judges were giving individuals the warnings that a conviction or a plea to a felony could adversely affect their immigration status. So what one would have to do is, if the records are still around, one would have to go and get a copy of the sentencing and the plea agreement from the court. One would also have to get a copy of the court reporter's notes. Now, here in Cuyahoga County in Cleveland, Ohio, I do know that after a certain time, the court reporter's notes are no longer available. Even though the files might be available, the notes are no longer available. If you can show that the court never gave you the appropriate warnings under whatever the statute is in your respective state, then yes, it is a possibility you could get that vacated. And then once it is vacated, it is a possibility that you could, even because it is so old, the prosecutor probably would not want to pursue it, or might give you something that is not drug related or less than drug related, but it will depend on your own state. But once that is vacated, then yes, it is possible that you could in fact adjust status here in the United States. But as long as that conviction is outstanding, it is going to be a problem.
This person is stating that happened in California.
Okay, then they need to get an attorney in California who's licensed to practice in California to see if that individual can go to that court and get the information that I just talked about and file the appropriate motion. Because I'm also pretty sure at that particular point in time, attorneys were not advising their clients as to the possible immigration consequences. Now, the marijuana piece, we might be able to get rid of that with no problem, because in California, it is my understanding they are one of 21 states, if I'm not mistaken, and my numbers may be off, that have legalized marijuana both medically and recreationally, but the cocaine may be a little bit more difficult. But if they didn't get the warnings, and their attorney did not tell them the warnings, then they have an ineffective assistance of counsel argument under the Sixth Amendment. In addition to that, they have an argument that the court should have told them, or at least made them aware that this could possibly negatively affect their immigration, their ability to adjust status here in the United States.
Perfect. Thank you very much, Attorney Rutanio. Don't forget that the phone number is 216-279-3984. 216-279-3984 is the phone number in the offices of Margaret W. Wong and Associates, with 7 locations across the country: Atlanta, Chicago, Columbus, Cleveland, Nashville, New York, and Raleigh, North Carolina. And it's just one phone number: 216-279-3984.
And if I may add, we do travel. We do travel all across the country.
They do. They do. I know some days. And before the pandemic, Miss Wong was going Mondays, New York, Tuesdays, Nashville, Wednesdays, Cleveland. Uh, Thursday, it was Chicago, Raleigh, Atlanta, or back then, Minneapolis in those days. And then Fridays would be Columbus, and then she would have the weekend at home. And so it was, she slowed down a little bit, but now all of you, because she doesn't travel alone, she travels with 1 or 2 attorneys to the offices that they are visiting. And the only reason why some attorneys don't go with her is because they have to go to court and fight for your cases. So it's a law firm that has over 15 attorneys working for your case and fighting for your rights. Hi, attorney. Thank you for this show. What happens when I drive with no license, have an accident that someone rear-ended me, and I left the scene? Is it a hit and run? I was not at fault, but in that county, if you drive without without a license, you'll get arrested.
That is true. I don't know what county that is, but in most states, if you drive without a license, generally, depending on what the procedures are in that particular county or that particular city, it is possible you could get arrested. Now, here in Cleveland, they generally don't arrest you for driving without a license, simply because the jails are full and that is not a violent crime. However, it is a hit and run if someone rear-ended you and they left the scene. If you left the scene, you could also be charged with leaving the scene as well. It is, both of you are, unfortunately, even though you were rear-ended, you could still face criminal charges because you did drive without a license. And also you could face criminal charges if you left the scene. And so the bottom line is that if the other individual did not leave the scene and you were able to exchange information, you should get yourself an attorney that does personal injury work, because they can, in fact, pursue that individual on your behalf to get your car fixed and or replaced, and or if you were injured, to assist you. But yes, you can be arrested for driving without a license and for leaving the scene even though you were rear-ended.
Yeah, so how about is to leave the scene when you are the second vehicle in the collision? Like if you are not at fault and you leave the scene, how bad is that?
That is still bad. You should, if you are involved in an accident, I don't care if you're a U.S. citizen or if you do not have status. The bottom line is you should stay there at the accident, because that causes additional problems and additional issues with the police and the prosecution wherever you live.
Okay, thank you very much, Attorney Rutanio. Our time is up, so it was really quick. I felt that like time flew. But thank you so much, because the conversations are really good and we get to learn a lot from you. So thank you so much for sharing your knowledge and for having this time to answer all of the questions.
Thank you for having me on the show. I really, truly do appreciate it. Ladies and gentlemen, Margaret W. Wong and Associates is a very good law firm. They're very conscientious. They care about their clients. And hopefully, if you have any issues, you'll come and talk to us. And if we can help you, we will do our best to.
Thank you very much. See you next time. Have a good lunch. And don't forget, the phone number is 216-279-3984. The attorneys in the law firm of Margaret W. Wong and Associates.